Thank you for coming to this seminar. My name is Darlene Rutkowski. I am the District Administrator for the Department of Rehabilitation, San Francisco District. I am pleased to serve as the MC for today's seminar titled Understanding Employment Issues for People with Psychiatric and/or Developmental Disabilities. Today's seminar is being presented by People with Disabilities Foundation, based in San Francisco, providing legal advocacy services for 8 counties around the San Francisco Bay Area. They also provide public awareness events such as this one. I would just like to recognize and thank them for putting together this event. Could we have a round of applause, please? The mission of People with Disabilities Foundation is to provide education and advocacy for people with psychiatric and/or developmental disabilities, with or without physical disabilities, so that they can achieve equal opportunities in all aspects of life. We will begin this seminar by screening a 5.5-minute portion of People with Disability Foundation's latest employment-related training video, Understanding Employees and Job Applicants with Psychiatric Disabilities. Thank you, Steve and Bruce, for making this video. Steve is the founder, interim executive director, and managing attorney for People with Disabilities Foundation, and could we give him a round of applause? So at this point, we are going to view the 5.5 portion of the video.
Once somebody discloses a disability and requests an accommodation, then the employer has a commitment to engage in an interactive process and figure out what accommodation is appropriate.
I see a therapist once a week, and I see a psychiatrist maybe once every month or two. It doesn't stop me from being able to work here. As a matter of fact, I enjoy working here.
Schizophrenia is one of the psychotic disorders, and the prominent features in schizophrenia, especially paranoid schizophrenia, is the presence of hallucinations.
So, for example, a person may perceive auditory hallucinations. They may hear voices or other sounds. They're often voices, but not always.
Scott's job coach, Charlotte, meets with his supervisor.
So how's Scott doing?
Actually, things are going very, very well. He just last month got our Associate of the Month.
Great, that's so good to hear. Any problems? Anything to work on?
One thing I really like to have him work on, if it's possible, I really like to have him open up a little bit and communicate with others. And since we are a team here, it will help him a great deal, of course.
She coaches me, she encourages me and motivates me to do better on the job. If there's some kind of problem I have at work, she'll let me know and tells me what I can work on to make things better at work.
If the person is a qualified individual with a disability who can do the essential functions of the job and they need a job coach to help them, I would say yes, an employer is obligated to make that accommodation unless they can come up with something else that would be just as good. Maybe they're willing to assign, maybe they don't want somebody else coming in from the outside. If they're willing to assign a colleague to work with that person to help them get up to speed, I think that would be acceptable. It doesn't have to be the identical request of the disabled party, but it does have to be something that will help them get on equal footing.
Her injuries are healing quite well.
Yes, doctor, but she still seems to be in a lot of pain.
As a registered nurse, Douglas worked for years in the ward of a large medical center.
Okay, I will write an order for a home care.
I'm diagnosed with PTSD, which is post-traumatic stress disorder. Some of the underlying diagnoses include depression, anxiety, panic attack, hyperstartle response, nightmares.
Post-traumatic stress disorder is a disorder that would be under the category of an anxiety disorder. And typically, the person who has post-traumatic stress disorder has had an experience that is severely shocking, where they felt their life was threatened, or the life of somebody that they care about was threatened, or they witnessed somebody else's life be threatened. Probably the classic example is the war veteran who may have witnessed bombings and dismembered bodies or things like that, that then stay in their mind as images that come back unbidden.
For me, symptoms go back to 1978 when I was in the military. Things always seem to be under control until something stressful starts happening in life or at work. When I get to the point where I start feeling panicky or the anxiety is high, and I start having chest pain, or I feel like the world's going to come to an end, or I feel like something bad is getting ready to happen, I can decompensate in a matter of minutes and fall apart literally right in front of your eyes.
Douglas, we've talked about the fact that you take too much time on these calls.
I know, and there's something I should probably tell you. I've been diagnosed with PTSD. I can go back and work on the ward.
I'm afraid that might be even more of a problem. There's really a safety issue here.
Okay, I'm qualified to do administrative work because of my master's degree in nursing.
Okay, I don't know what positions might be available, but let me look into that for you.
I think absenteeism and psychiatric disabilities is a complex issue. It's complex for the individual who wants to get to work and be a participant in their job. It's complex for the employer who has basic job requirements that they need. And I think that's where it goes down to, is that there are basic job requirements. But there are ways to kind of think outside the box, so to speak. It may be that one way to reduce absenteeism is with flexible scheduling.
I just wish people would focus on the abilities that people have rather than on the disabilities that people have. Because there's so many people who would fit under the Americans with Disability Act that have fantastic abilities. And I'd also like to remind people that any one of us can become disabled at any time. And we really need to be a lot more sensitive to that issue and make sure that we're extending every opportunity to people to create a level playing field so that they can get into the workforce, so they can contribute, and they can really make a difference.
We'll be speaking today on the topic of how supported employment programs can help people with psychiatric or developmental disabilities succeed in the workplace and the types of services that are available. So at this point, I'm going to turn it over to Stephen.
Okay, thank you, Darlene. And I wanted to, as moderator, start the questioning of the panelists, and I'm going to first ask Claudia Center, our legal expert, to briefly explain the legal framework relating to rights and obligations of both the employee and the employer under the ADA, but also under the State Fair Employment and Housing Act here in California. Claudia?
Sure. I think I'll go up so that I'm on the mic. Basically, all of the different conditions that were mentioned on the video, and pretty much any condition that's well known enough to have a label, is probably now, in 2009, going to be covered by at least the state law, which we call the Fair Employment and Housing Act, and probably the federal law now that it's been amended, so the Americans with Disabilities Act. So, for example, PTSD. I have many clients with PTSD, most often from combat or from domestic violence or violent crime. Those are the two most common I see, but it could be from other experiences as well. Bipolar disorder, depression, obsessive compulsive disorder, other kinds of anxiety disorders, learning disabilities. Increasingly, we're seeing, I call them kids, but they're really not kids because they're over 18, but kids who are aging out of special ed. And so what are their disabilities? And so those folks are covered by at least our state law. People with Asperger's who are on the autism spectrum. I have many clients with those labels or disabilities. And developmental or intellectual disabilities as well. So all of these kinds of conditions are covered by certainly our state law and definitely the federal law. I mean, and probably the federal law. I'd also like to give a shout out to Joan Ehrlich, who has died since making this video, but was a fabulous advocate for people with disabilities. And it's just amazing to think about all of our California advocates. The reason that our state law is so broad for people with disabilities was in large part for an advocate named Prue Popping, who was with the Fair Employment and Housing Commission for many years and is also no longer with us. So I want to just remember some of our great advocates. So what are the protections, Stephen asked me. Basically, I kind of think of them in three piles. First of all, there's the protection against basic discrimination, sort of old school discrimination. So for example, we don't want anybody with, this condition. We don't want an autistic person, or we don't want a person who's crazy, or we don't want a person, who has seizures, out and out garden variety old school discrimination. That's prohibited by our laws. And, if the employer were to engage in that kind of conduct, the employee could complain, could file a charge of discrimination, could try to get a remedy for that, could try and pursue their legal rights. Sometimes it's not quite so direct, but it's also what I would call garden variety discrimination, and that's when the employer reacts to something that is so close to the disability that it's basically part and parcel with the disability. So for example, a reaction to somebody's behavior when the behavior is caused by OCD. So for example, I had an employer, and this actually took a lot of education and back and forth. The employee had OCD and was engaging in some food hoarding behaviors at work. And they were weird behaviors to people who don't have this behavior, this aspect of OCD. So we had to educate the employer, we had to talk to the employee, try to come to a common ground and that would work for both sides. So reacting to behavior that's very closely associated with a disability is a kind of discrimination. The second area where there are rights and remedies and obligations is the one that we talk about most frequently and is the one that's most complicated. And that's the right to reasonable accommodation. In that area, the employee has obligations, the employer has obligations. Generally speaking, although there are a number of exceptions, the employee is the person who is supposed to start the process of accommodation by coming forward, letting somebody in HR or letting someone who represents the employer know that there's a disability, that the person has a disability, and that there's some need for some kind of change in the workplace. So that's kind of, and again, there's some exceptions, but that's basically how the reasonable accommodation process is supposed to start. Then at that point, there's this sort of idealistic phase that sometimes works and sometimes doesn't work that we call the interactive process. And during that phase, the employee is supposed to give the employer information about their disability and about what their needs are, what their strengths are. The employer is supposed to give information about what's possible, what can be changed on the job. And together with all this communication and exchange of information, the idea is that an accommodation will be implemented and there will be a more successful employment experience. Someone asked me right before we started about is there a list of reasonable accommodations? And basically the answer is no, but there are some that we know for sure are your standard reasonable accommodations. So those would include things like, and I'm sure any of you could come up with some of these on a list, but like a modified schedule. Say somebody has an issue with medication or an issue with fatigue or an issue with doctor's appointments. They might have a modified schedule. Schedule changes to make sure someone has stable sleep. A lot of people can't work the swing shift. I mean, it's probably not good for anybody, whatever their disability status, but some people need to sleep regularly in order to keep stable and to be a successful employee. So that kind of schedule. Telecommuting is sometimes considered a reasonable accommodation. It's going to depend on the job. Modifying an employer policy. Say the employer usually doesn't let people wear, headsets, listen to music on the job. If that were part of your accommodation, then that policy would have to would be modified as an accommodation. Job restructuring. If there's some piece of a job that an employee can't do because of a disability, that piece can be reassigned. Environmental changes. These are very important, especially I've been noticing recently around PTSD and learning disabilities. Reducing distraction, creating a more secure, quiet environment. That's very good accommodation for some people with certain disabilities. Equipment, of course, may be part of an accommodation. Time off for therapy. Changes to communication styles. This is a hard accommodation because it's hard for people to change their communication style. But for example, if a supervisor is very disorganized or is very negative or not very clear, this is bad for everybody, right? They're not being necessarily a good supervisor, but it can be particularly bad for people with disabilities. So, there can be an effort to change communication, to have more frequent check-in, positive as well as negative feedback, that kind of thing. Job coaching, I think, was mentioned on the video. That can be a reasonable accommodation. And leaves of absence is another very common accommodation. So, but that's not like a finite list. It's really just whatever the creativity of both sides can come up with, it may end up on the list of reasonable accommodation. And then the third sort of area where there are rights and remedies and obligations is around medical privacy. There are rules under both the state law and the federal law about how employers are supposed to maintain medical and disability-related information, and it's basically confidential and a need-to-know basis. So that's for all, actually those rules apply for all employees, not just employees with disabilities. The employer is supposed to maintain in that way. And so those are the areas. And one thing I actually really like about the rubric or the framework of reasonable accommodation and is the person qualified and can they do the essential functions of the job, is I actually think it's a great way to look at the world generally, whether or not one's employees have disabilities or don't have disabilities. Just that's a great way to manage, is just to think about what can the person do, can they do the job, can they do the essential job, what do they need to succeed. I mean, I kind of think everybody should have reasonable accommodation if that's what makes them succeed. And we have it limited at this time to disability, but it's really just common sense. It's making the most of your employees. So that's a quick overview. Stephen, do you want me to talk about some other areas? I mean, there's certainly many areas.
I think for now, if anyone has any questions relating to the legal framework and what Claudia was just talking about, we'll take those now before we move on to the next speaker. The gentleman in the black gray sweatshirt. And do we have a cordless mic?
If not, I'll repeat the question.
Thank you.
I'll try to speak loudly. My reaction to what you just showed is shock, because it isn't the way it happens.
I appreciate that. I said the idealistic part.
Yeah, that's not the way it goes. I have a disability. I have an 81-page form to fill out now for SSDI. 2 employers told me that they don't make accommodations for my disability. I brought prescription bottles in. They had a lien on my house because they relocated me here for the job, and it's a condition I developed during the process of relocation. And they were going to throw me out on the street. So I had to settle for whatever. And I owe thousands of dollars. I have had to take the loan out for $50,000 for my family just to live. And this is a healthcare company in the city, Genentech, who basically said, we don't do that. And I worked in the department that helped people find insurance coverage who couldn't afford insurance. And I've got a diagnosis now, a firm diagnosis of a disability, and it was a social worker who fired me. What are we supposed to do? How do we navigate this whenever people like that won't even listen to us. I had a note from a neurologist, I had all my medical records there, and the HR person just said, they split it up so the supervisor wouldn't talk to the HR person. I was going back and forth. I got in trouble for being late to a meeting because I was talking to the HR person across campus about my disability, and she wrote me up for being late for my review. How are we supposed to do this?
I hope everyone heard the comments, which is about the great disconnect in many, many circumstances between the ideal of the law and the principles of the law and what actually happens in the real world, particularly during the interactive process, is when a lot of...
Excuse me, there was no interactive process.
Right. No, I understand. I appreciate that.
Who was watching those people?
Right. You know, either the employer refuses to engage in the interactive process, or the employer purports to engage in the interactive process but uses that process to delay any accommodation. I've certainly seen that in a case that we're litigating right now, where the employee kept bringing in documentation of her learning disability, and every single time it was not enough. It wasn't the right exact wording. And, you know, I've been doing this area of law for about 14 years, and I looked at the very first piece of paper and I said, well, I think that's fine. And then I looked at her second piece of paper and I said, well, I think that's even better. And then the third piece, and it took months for, and again, it was a healthcare employer, it took months for them to accept the documentation as meeting the requirements, and then ultimately the accommodation wasn't provided. You know, I think that I don't have any magic answers. We try to enforce the law. We try to educate employers. We bring litigation when we can.
Let me share something
Sure.
with you. Where the law falls short is I was under duress to settle. I went to mediation, and if I wasn't going to be able to even have a place to live, I had to settle. So I settled owing all kinds of money. And the only people that made money was this big audit firm over here on Howard Street. And my attorney, who I still owe, and I have to go to the Bar Association just to try to manage through what I owe for this. And no one's out there saying, you know, Janine Peck, you didn't do what you were supposed to. And that to me doesn't seem quite right.
Oh, it's not right at all. I mean, there's a great disparity between the resources available.
But I can't go back now because I settled.
No, I understand. I mean, I think that is a very common experience. People do settle because they have to move on. They take a severance even though it's their actual injury is much greater than the amount of the severance. That's certainly a very common
How many people are going to
experience.
lose their home?
Yeah, I agree. And, you know, it's systemic. So, you know, we can advocate for more money for the EEOC to investigate. We can advocate for more money for free legal services. You know, some people end up having a positive experience with the legal system. Many, unfortunately, have your experience. I think healthcare employers tend to be, I know that we have healthcare employers here, but I think healthcare employers tend to be some of our worst employers in terms of disability. I think there are a number of cultural reasons for that. But I certainly, it's a trend that I have seen in my practice area.
Okay, there was the gentleman in the blue shirt.
So,
Yes.
for reasonable, is a personality disorder something that's clearly you deserve or you're entitled to the accommodation?
That's a great question. The question was, what about personality disorder? And I think you mean like access to kind of stuff, like
Yeah, borderline, narcissistic
yeah.
personality. I mean, I thought about this when you said that the manager who has, you know, really poor management skills needs to try harder to be. But if someone has a personality disorder, I mean, you really can't expect them to change much. I mean, particularly if they want to acknowledge, you know, I'm a borderline personality or I have this.
Well, let me answer it a couple of ways. I'll answer it the the theoretical legal way, which is that there's nothing in the state law or the federal law that excludes personality disorders from the protection. So it's not as though there's some, line that says these protections don't apply for someone with a personality disorder. And I'll also, as an aside, state that, every term, in access to and associated with personality disorder, as it, quotes, is a contested term. It's a very controversial area, so I don't want to make it sound as though I'm buying into the entire DSM, rubric of how this all works. But there's no exclusion of personality disorders. That being said, if somebody is unable to interact with others, say, or unable to politely interact with others, and let's say interacting with others is a core function of the job, then that person may not be qualified. If the person is able to do the functions of the job, and maybe they're kind of a pain, but they can still do the functions of the job, and customer service or whatever isn't a core function, then they may be qualified with their disability. So that's, and then, the real world answer is that lawyers generally are going to look for something that's not a quote-unquote personality disorder as the label. So if a person with a personality disorder label went to legal services or a lawyer for assistance in the underwriting process, probably that advocate is going to look for something, you also have depression, let's focus on that. So that's kind of the real world way that advocates try to navigate the stigma associated with the label personality disorder.
The young lady with the blonde.
Thank you very much. Quick question. How does the HIPAA law help with these healthcare companies? I actually have a client that has worked for a drug company also, whose prescription drugs, their healthcare insurance, actually had the prescriptions filled at the place where they were working because that's where the business was being drawn. He got a lot of crap because there was, chit-chat, going back and forth and whatever. Is there anything we should do different?
Well, actually, that's a great question, a very sophisticated question also, which is, how did the HIPAA, the privacy protections, help with employers that play two functions? A lot of healthcare employers are both the healthcare provider to their employees and they're the HR employer to their employees. What we always said before HIPAA is that these non-discrimination requirements of state and federal law, implied in those requirements was to build this wall between the healthcare function and the employer function. And what HIPAA did for us, which we very much appreciate, is that HIPAA said, yes, absolutely, you have this wall under HIPAA. So even if you didn't buy our argument under the ADA and the FEHA, now that wall is required by the HIPAA. We actually have a case right now against Kaiser, where it's all filed in public court, so it's not secret, where one of the allegations is that a report created on the healthcare provider side was transmitted to the employer side without the appropriate authorization. I do think things have improved because now everybody agrees that wall should be there, which is not how it used to be exactly. But it's still a process, and there's no private right of action under HIPAA, meaning you can't sue an employer or a healthcare provider under HIPAA directly under the federal law. There is a possibility of crafting a state tort or a state, there's something called an unfair business practices claim, and you can maybe tie that to a HIPAA violation. But yeah, we're still in process there.
Okay, Dr. Janice Cohn would like to address, I think, the first gentleman's
The question about
question.
personality disorder. I just wanted to say the two issues. One, that personality disorders are treatable. So the issue about whether it's treatable or not is a moot point. The one relevant, I think, piece is the health parity law in California. which basically under insurance coverage says that if you have a severe mental illness, which is one of about 10 diagnoses that does not include personality disorder, your mental health benefits have to be at parity, which means equal to those of your medical benefits. So were this to come up as something that were in fact considered a severe mental illness, it would not be under the parity law. And that could be probably argued that it wasn't covered under ADA. But I just wanted to clarify that I think that's a kind of a side issue, but it is a legislation that on a federal and a state level that could be used as an argument against the coverability of a personality disorder.
You're saying there's only 10, about 10?
Yeah,
severe
and personality disorder is not included in the parity law for California.
For California, there's a federal parity law that is not diagnosis-based, is my understanding, although I'm no expert in that area.
Okay, the lady in the white shirt in the back.
Are there ever times when an employer is protected from denying a reasonable accommodation request?
The question is there ever a time when the employer is protected from providing a reasonable protected for denying a reasonable accommodation request?
Yes.
Well, I mean, this is the area that drives everyone crazy, which is that all of the answers are it depends, and once you get into reasonable accommodation. So let's say somebody asks for an accommodation and it's not facially reasonable. That's like I know that's a vague way to say it, but that's what the Supreme Court said, that an employer doesn't have to provide an accommodation that's facially unreasonable. So let's say somebody said, I have problems riding public transit because of my OCD, so I want you to hire a car and a driver, a limo or whatever, to come take me to and from work. No one's ever litigated that case, but I imagine that some court somewhere would say that's facially unreasonable to hire a driver and car for you because of your problems with transportation. I don't know for sure. I mean, maybe someday somebody will win that case, but right now I think that's what a court would say. So the employer wouldn't have to provide that kind of accommodation. The employer would have to talk to the person and say, well, what's your issue with transportation? How can we get around it? Can you come at, not at rush hour? Would that help? That kind of thing. Can we change your schedule? So there can be a back and forth. The employer can provide a different accommodation. The employer can request reasonable medical documentation if the employer thinks that the employee is, doesn't actually need accommodation, but is just sort of saying it for other reasons that they need accommodation. If the accommodation would impose an undue hardship, the employer doesn't have to do it. So there's kind of a lot of factors that go into it. But one thing that happens sometimes with my clients who may be unsophisticated is that they come up with accommodation ideas that probably aren't reasonable accommodations. I had one client who at one point suggested that his employer monitor his medication compliance, which really is not considered a reasonable accommodation, and that's probably a good thing. But even though that was probably not a good idea, he at least was trying to brainstorm a reasonable accommodation. So the employer would then still have an obligation to say, okay, well, I can't do that, but let's think of something else that we could do.
Okay, the lady in the blue t-shirt.
Hi. Because it's hard to be able to get a job if you tell your employer that you're disabled in some way, would it be acceptable to apply for a job, not reveal your disability, get the job, and then if you can't handle the way the job is, then ask for reasonable accommodation?
That is not only an okay way to do it, but it's actually the way that most people do it. Let me repeat the question. The question was, since it's hard to get a job, is it okay to be hired for a job, not reveal a disability, see how it goes, and then if down the road you need an accommodation to raise the issue then? That is how most people do it. That's the reality of our world. most people don't disclose their disability when they're being hired. There are, many exceptions to that rule, but as a rule, most people don't. And, down the road, if someone thinks they really need an accommodation, then they are the only ones who are going to be able to make that decision as to whether they're going to disclose to their employer. That's a whole process that should happen even before reasonable accommodation. So for example, if I were advising somebody who was thinking about disclosing, I wouldn't automatically assume that they're going to go ahead and disclose. I would say, well, let's think it through. What are the pros? What are the cons? You need to make that decision. On the one hand, disclosing might get you an accommodation. On the other hand, disclosing might, have negative effects. So it's balancing, and really, the person in the job is the only one who can make the decision. It's their life, it's their disability, it's their information. They're the ones who know the players and whether it's going to help or hurt. Sometimes there's very little choice. The person, it's either disclose or they're going to be out of there for various reasons. But, it is a choice the person has to make themselves. But there's no rule that you have to disclose right at the beginning.
Okay, we can take one more now, and then we want to move on to Dr. Gilbert to go over some of the most common disorders in the workplace and the associated symptomatology. But this gentleman in the plaid shirt had a question.
I actually have two questions, but what is the limitation between what information personnel or human resources can share with the supervisor about a medical or psychiatric condition? Because I know where I've worked, oftentimes the supervisor will require documents from doctors to come through them, which they need to go to personnel, and then there's, so what are the rules regarding that area, number one? And then are there any rules regarding disclosure by personnel to the employee as to what they're doing to try to accommodate them? Beyond, just the interactive conversation. To actually document, well, we've talked to this supervisor, that supervisor, that sort of thing.
Well, the first question was about what do you do with medical information, to whom do you provide it? And what the regulations say is that medical information is, and this is again this ideal area as opposed to the real area, but the ideal is what the regulations say. Medical information is supposed to be maintained in a separate confidential file that's in a locked, secure location. Now that's the ideal, that's what's supposed to happen. We use that regulation to argue that it's, that someone who is turning in medical documentation should be allowed to give it to HR, not to their supervisor, and that HR then would only share the information that on a need-to-know basis. So we do make that argument. That's not always what happens, but that's what we think is consistent with the regulations. In terms of the interactive process, again, it depends. There are no rules for what needs to be documented. We certainly, as we advocate for employees who are in the process, we try to encourage employees to take notes, to set up meetings, to confirm the meetings in an email and print out the email to just show, with a paper trail, if possible, that they're doing what they can to participate in the process. And to not, in the interactive process, sometimes there's a back and forth. So let's say somebody suggests an accommodation that's undoable, let's say for a good reason. Let's say the employer says no for a good reason. And, but then nothing more happens. We always encourage the employee to keep going, keep trying, because what the courts will say is whoever drops the ball first from this back and forth is the one who legally tends to lose their rights. So we want to keep the employee talking. And especially with HR knows that rule too. So the more the employee talks, the more HR will have some incentive to respond and to provide accommodation. Again, ideal, not necessarily real.
Claudia, I have one question which later on I think maybe Dan Daniels may have some input on, but it's related to what we're talking about. I was a speaker at the Veterans Administration down in Palo Alto. It was management. There was a room with employers there. And one particular manager said that someone who she supervises got a new job description, not too much different from the old one, and he'd been there for 20 years, but she felt he, the employee, could not do it. She believed he was mentally impaired and knew where his chart was because the clinic and the hospital was really just down the road, but she knew or believed that she was not permitted to go down and look, and she was in a quandary. And she decided that she wanted to take disciplinary action, which was suspending him for 6 weeks without pay. And this kind of scenario comes up.
Colleagues on the other side of the aisle who represent employers, but my view is that there are ways to open up a dialogue that I think are lawful and not particularly risky for the employer without divulging confidential information. For example, the employer can say, it seems as though you're having problems with, job function X. Is there anything we can do to help you with that? I hope you know that we have these policies to help you succeed at your job, and that includes the reasonable accommodation policy. And I hope that you come to me with any needs that you may have to try to make sure that the employee knows that there is that opening. And that doesn't violate any rules.
Does that regarded as language in the definition of disability play any role in this? Whereas this supervisor believes the person has a severe mental impairment, but that's all she really knew. She didn't know the diagnosis. And I don't know what facts led to that, but she, in at least one sense of that, regarded as terminology, really regarded him as having a mental disability. All I said was, well, I really think she might want to consult with her HR department before she, under those facts, took action.
Well, that's the fear that my colleagues who represent employers have, is that opening that conversation could be used, and I actually disagree with this because I don't think the case law shows this, but their fear, which is driven by sort of a zero risk kind of approach, their fear is that that kind of opening would somehow be used by the employee down the road to show that the employer regarded them as having a disability. But my view, based on the case law, is that the employer could at least say, please let me know if you need any help. Please know we have these policies, including reasonable accommodation policy. I don't think there's a court that would say that means that you definitely regard the person as having a disability. That's my view. But again, I don't represent employers, so I'm a little biased.
Okay, thank you.